I just want to go back to one other element of this as we talk about this distinction between restricted speech and compelled speech, right? Because I know that you've looked at the transcripts from the oral arguments yesterday. People were waiting there wasn't a lot of suspense about this. People sort of knew that where the different players were after Friedrich's, the case that ended up being stalemated because Antonin Scalia was quite timely in his exit from his presence on our Earth, and I'm not going to put you in a uncomfortable situation of sharing my continued emotion about that, but be that as it may, so this Anthony Kennedy wrote. And I'm not sure which case it was. I don't know if it was the Abood case or one of the subsequent cases, Knox or others, that government employers, like private employers, need a significant degree of control over their employees' words and actions. Without it, there'd be little chance for the efficient provision of public services. So in other words, if I'm the city of Chicago and I have deemed that I am going to this is going to be a union shop. The union statutorily represents everyone in the office, essentially, and therefore I'm exercising a certain amount of control. I can restrict their speech to a certain extent because they're my employees. But this guy's argument is different, that he's actually being compelled to say something, to be in favor, let's say, of more government spending. What's the difference between, historically in the law, between compelled speech and restricted speech, and as someone where does Sam Alito, a strict constructionalist, or Neil Gorsuch, a strict constructionalist, see this distinction between compelled speech and restricted speech? Because it occurs to me that restricted speech would be almost worse than compelled speech, because it's compelled speech is more of like an inference, right?
Well, and I think particularly in this case, because Janus is not actually being compelled to speak. Janus is being required to fund someone else, the union, which is then speaking. Janus has every right to go to the government and lobby in opposition and to speak out in opposition to everything that the union is saying. He can, yes, he has to pay this fee, which is then used by the union. And so in effect, he is subsidizing, in a way, the union speech, if in fact collective bargaining is political speech. But he has a complete right to do any number of things. He can speak himself and say what he believes in opposition to that.
He could stand outside of that. He could stand outside of that bargaining room with the sign that says, "Don't pay us more money."
Right, absolutely. He can email his employer. He can go to his boss. He can say anywhere he wants to. He can go to the Illinois legislature and say, "Don't appropriate more money to my agency so it can pay additional money to the employees under the collective bargaining contract." He has a right to try to get rid of his union. There is a whole process under the law where you can what's called decertify the union. So if he can convince enough of his fellow employees that the union is not doing a good job, they can vote the union out. They can vote a different union in. They can have no union. There's a whole process for that. So he has a lot of rights, and I think this kind of, if we want to call it compelled speech, is something somewhat different than if Janus was, somebody put a gun to his head and he had to stand up and, proclaim something that he did not believe.
Or even if they said, we're going to fire you from this shop. I mean, this isn't even it doesn't even seem to be like any economic coercion. It seems to be to the extent that he's being coerced to subsidize this speech, and I think that's as far as it goes, he is being coerced to do so by statute. And isn't it statute that coerces me to pay taxes? And certainly the government expends money in ways that I don't like. And so how is that not compelled speech?
Absolutely. And the government, the union is a democratic institution. So the union can be voted in and voted out. The same as our representatives can be voted in and voted out. And we do that on a majority basis. So if a majority of us vote in someone, I may not like them, but they're my representative, and they represent me until I convince a majority of my fellow citizens to vote them out. And they may vote to do things that I don't like and to spend my tax money in ways that I don't like. But that's our system, and our collective bargaining system in the United States is based very much on a similar principle. The majority rule, the ability to convince the majority to get rid of the union, the ability to speak out separate and apart from the union, all of that is built in. So it's very much a system like our political system.
I'm super like the first thing that really comes to mind is this car insurance, because every state in the country, you are compelled to buy car insurance. And just like I'm not compelled to work in, for the sanitation department of the city of Chicago, I'm not compelled to drive my car. But if I want to work for the sanitation department of the city of Chicago, I got to pay these agency fees. If I want to drive my car, I got to pay for this car insurance. But these car insurance companies, there is no doubt in my mind that they have lobbied the U.S. government, or that they've actually, they belong to some groups in some fashion or another that expresses a political idea that I don't like. And I just don't understand how I can be compelled, after Janus is going to be found, and I think there's very little suspense about this, how I can be compelled to pay car insurance at that point.
I think we're going to see those lawsuits. And actually, interestingly, there's several unions in Illinois and Wisconsin that have already filed some lawsuits in anticipation of Janus. One of them is filed against a community in Illinois, I think it's Lincolnshire, where the individual is saying, my tax money is being used by my community to lobby for things that I object to. They're a part of the Illinois Municipal League, and the Illinois Municipal League has lobbied for right-to-work laws and in opposition to public sector bargaining. I'm a union member. I believe in public sector bargaining. I oppose right-to-work laws. My tax money is being used, that I'm compelled to pay to my city, is being paid to the Municipal League, another organization, to do things that I object to. So there already has been, to my knowledge, at least one lawsuit that was filed last week in anticipation of this ruling in Janus.
And my understanding is
we'll see more of those.
There's a suit in a federal lawsuit against Scott Walker in Wisconsin, because the law he signed in 2011 restricts public employee collective bargaining rights. And the theory is that if collective bargaining is speech in the Janus case, and therefore he's being compelled, his speech is being compelled. In this instance, the restriction on collective bargaining would be a restriction of free speech. I mean, how does restrictions on wildcat strikes under Taft-Hartley, how does that stand? I mean, if the act of collective bargaining can both restrict, can compel free speech, then clearly the prevention of it or the subjugation of it is a restriction of free speech. Then how can you have no strikes? How can you have no wildcat strikes? How is that possible? How is that not all a restriction of First Amendment rights? Or is that just like there was found that the government has a compelling interest?
Well, I think, yes, you have to look at whether or not there's a compelling interest. And there might be a compelling interest in those cases. But it does raise, I think, the issue again, because we have not said in the past that collective bargaining is political speech, and political speech is speech of the highest order. We have treated collective bargaining as, a form of, some people have called it economic speech, but at the very least, a form of speech that has less protection than political speech, which has the highest form of protection. So if it is the speech that has the highest form of protection, then the government interest has to be much stronger in limiting it. And it might be that in certain kinds of cases of strikes, the government interest might be found to be sufficiently compelling.
First responders, let's say, as an example, right?
Exactly. But I think in other sorts of situations, for example, teachers are prohibited from striking in most states, not all states. All public employees are prohibited from striking in many states, in most states. So why is it, the clerks in the water department, they are prohibited from striking? Why is there some compelling interest in prohibiting those individuals from striking? They're not like first responders.
So just to be clear on this dynamic so that people understand, pre-Janus, let's assume we're living in a post-Janus world, because I think we're about 6 months off from that. But in pre-Janus world, the government could say that the guy or the gal working in the public works department as a clerk can't strike because the government has a compelling interest. It's not hugely compelling, but it's compelling enough to meet the standard of suppressing economic speech, for the lack of a better term. However, post-Janus, that economic speech will be elevated to political speech, which requires a higher compulsion need by the state, the government, to subjugate that speech. And this is going to open up that question now anew, because the speech itself has been elevated in its requirement of the compelling interest by government.
Yes, that's exactly it.
Well, this should be interesting. And like you say, guys like Eugene Volk, I don't know if I'm pronouncing his name correctly, have put in amicus briefs arguing with, on the side that people like you would be arguing, I would imagine, that this is going to open up a lot of problems, perhaps. And the point is that this notion of compelled speech that are not generally viewed as burdening any First Amendment interest, there could be a lot of cases. And we still, despite the fact that Donald Trump has been quite vigorous in appointing federal judges, we still have like a lot of federal judges out there who are going to basically take that element of Janus and perhaps apply it to other scenarios. Is there a way that a guy like Alito, it seems to me, or Gorsuch, could fashion the Janus ruling in such a way that they do one of those like, hey, it's just for this scenario type of thing?
Well, I think that may be what they might try to do, and I think there is an element of this that is how it fits in their mindset. That is, there's an element of sort of unions are bad and collective bargaining rights aren't important, and we don't really understand or support the whole system. So therefore, it's not important. There's not a strong interest here on the part of the government. So I think it's more in balancing the interests that they think they can make this distinction. And of course, whenever you have a balancing test, those are good tests in a sense because you can take into account a lot of interests, but as people often say, sort of the weight of various interests is in some senses in the eye of the beholder.
Right.
And the beholder, is the judge. So I think that's where they think that line can be drawn, but not everyone sees it in the same way. I mean, I think there are other ways that this decision might be compromised, but I'm not sure that. I mean, certainly I don't see Alito going for a narrower compromise. Justice Gorsuch, of course, was completely silent in the argument, so. We have no sense from the argument as to how he might go. We probably have a sense. I think the reason people are predicting that Janus is going to win is his general judicial philosophy and conservative background.
Let me, and I think that was a very polite way of you saying that with some of these justices, they have a preordained outcome that is a function of their political ideology. Maybe not. I don't want to put words into your mouth.